Good morning. Welcome to Tuesday Talks with the Minnesota Association of Realtors. My name is Chris Galler. This morning we're going to discuss seller disclosure and seller disclosure for bank-owned properties as well. One of the questions that we commonly get at the association is related to, do banks have to disclose material facts? In some transactions they refuse to. In other transactions the agents have asked for seller disclosure forms. It's important for agents to understand this law. On the Minnesota Realtor website you can download the Realtor Reference Guide, which has a number of pages related to the seller disclosure law. Bank sellers are the same as any other seller that owns property in the state of Minnesota. That's very important. But it's also important to realize that sellers, whether being a bank or not, have three options. One is the option we prefer, that is full seller disclosure. That means that the seller discloses all that they know about the property. The second option is to have an inspection of the property and use that inspection as the groundwork for disclosure. So it could be that a bank has inherited a property or taken one back, unfortunately, and they're not fully aware of it, but there is an inspection that's been done. Maybe it's a city inspection related to code compliance. They have that inspection, and they have a requirement then to provide that inspection plus any additional information they may know as the owner of it that wouldn't show up in the inspection. That's their second option. Their third option is a full waiver. And Minnesota state law does provide that sellers, including bank-owned properties, could waive their duties so long as the buyer accepts a waived disclosure. The important difference there is that as agents, you must always disclose everything you know. That puts you in a difficult position with a bank-owned property where you know there's a problem and the bank does not want to disclose it and is seeking a waiver. That waiver does not protect the agent. It only protects the seller. The agent, under your fiduciary duties, would have to disclose to the seller bank that you have a duty under state law to disclose that. This information is on our website under the Realtor Reference Book, back in the section called Material Fact Disclosure for Sellers. You also have a number of forms that you can utilize, the full disclosure forms, which now are 5 pages long, or there is the seller's alternative, which can be used if somebody is going to depend upon an inspection or if they're going to look to waive. We also are careful about the waiver. We're unsure yet, because there has been no court cases, as to how the courts will perceive a seller that seeks a waiver knowing that there is significant problems with a property. Let's say that a property has a cracked foundation or a leaky roof. The seller knows it, does not want to disclose it, and tries to get around it using the waiver. Minnesota law allows him under the waiver to not disclose. We're just not sure if a buyer, once signing up to that, would be able to sue the seller in court. Again, the key of material fact, seller disclosure, is that that does not cover the licensee. This is only for the seller. Licensees have a duty to disclose no matter what. If you have questions, you can refer to the reference guide, or your broker can call the legal hotline, one of the services of the Minnesota Association of Realtors. We thank you for being with us today. We look forward to talking to you next week.